Okay.
Thank you.
Thank you, Malala. I confirm my attendance we are talking about 5. Thank you.
Okay, thank you. Yes.
As the court please, my lord, the matter is set down to today for hearing of argument by accused number one's counsel for discharge in terms of section 174, as well as the response of the state to that application. There were timelines that were set down for the submission of the heads of argument by the counsel for accused number 4, as well as for the state. Both parties have adhered to the timetable,
Yes.
and hard copies, my lord, have been prepared for the court and have been given to the court's registrar this morning. Both
Okay.
the heads for accused number 4 by his counsel, Advocate Numalo, as well as for the state. But just before we commence, my lord, Advocate Nisi has intimated that there is something that they want to put on record. I'll just take my seat and allow him to address the court.
As it please the court, my lord, it's not a big thing though. It relates to Mr. Sibiya. Apparently there's a misunderstanding where he's being housed at Morabi Correctional Facility about the court starting time in the matter. Because apparently the head there, I don't know whether it's a head or it's a divisional head, keeps on receiving messages, phone calls, I don't know from who, to the effect that the starting time of this court here, it's 9 o'clock. So I don't know where that comes from. So apparently he requested through Mr. Sibiya that at least the court should clear the starting time of this matter, my lord. I've been saying to him, no, the official starting time of this matter it's 10 o'clock. I don't know where the 9 o'clock comes from. So is it now? I think that needs to be cleared, my lord. I think there's a gentleman there who also can affirm that position. Is also from Morabi Correctional Facility, my lord.
Okay.
Thank you.
Yes, say, who is the gentleman? Yes, let's hear. What do you know about this 9 o'clock, 10 o'clock story?
We were also told this morning that we should be here at 9. So we should give more than as early as possible. That's the message we got.
Also, it's an instruction from your section.
Yes.
And if you're not here at 9, what happens?
I don't know much, but it just came as an instruction that.
Yeah, okay, no, fine. The court starts at 10. So if the gentlemen before us come at 9, it's still okay, because at 10 o'clock they'll be here. Okay. That's the official starting time.
Thank you, madam.
10. Okay, thanks. Yes, Mr. Newman.
My lord, I'm ready.
Yes.
To
Are we
proceed.
ready to start, Mr. Barui?
Indeed, my lord.
Okay, so, yeah. Yes, sir.
Thank you, my lord. This is an application in terms of the provision of section 174 of the Criminal Procedure Act 51 of 1977 with respect of accused number 4. Introduction. The provisions of section 174 of the Criminal Procedure Act, the Act provides as follows. If at the close for the prosecution, for the case for the prosecution at any trial, the court is of the opinion that there is no evidence that the accused committed the offense referred to in the charge or any offense of which he may be convicted on the charge, it may return a verdict of not guilty. The background. The deceased Mr. Senzo Meyiwa was a well-known professional footballer who played for Orlando Pirates as a goalkeeper in the Premier Soccer League, and for the South African national team Bafana Bafana. The deceased was shot and killed in the house of his ex-girlfriend, Miss Kelly Kumar, on the 26th of October 2014 while paying her a visit. On the 16th of June 2020, the investigating team led by Brigadier Geninda, who is the head of the National Court Cases, arrested Bongani Ntanzi, accused number 2, in respect of this case. On the 19th of June 2020, accused number 2 made a confession statement before a commissioned officer, Colonel Rapado. On the 24th of June 2020, accused 2 made a second confession statement before a magistrate, Ms. Cronje. It was on this basis that a confession statement which led to the arrest of accused number 4 before court. On the 17th of July 2023, the trial commenced de novo, and it has been on a running roll for a period of over 2 years. It has been televised national and international and on print media. It has also been marked by delays during this period. Accused number 4 has been in attendance throughout the trial. It is no doubt that at some instances, valuable court time has been wasted. The rationale for Section 174. The rationale for the rule in terms of Section 174 was described as in State v. Morera, unreported GP case number A523 of 2015, dated 22 January 2016 at paragraph 54. And I quote, "It caters for the prescript of the Constitution for the fair criminal trial, namely the presumption of innocence on the part of an accused until proven guilty and his or her right to silence. It further puts an abrupt end to a case which has no prospect of being successful in circumstances where the evidence falls abysmally short in proving even a prima facie case against an accused, thus ensuring that valuable court time is not wasted and unnecessary expense is not incurred." Section 174 thus gives the court to decide not to put the accused on his or her defense if there is no case to answer. There is no formula for or test applicable to all circumstances when deciding whether or not to discharge. Each case must be decided on its own merits in order to reach a just decision. Discharges. The accused, including accused number 4, are charged with the following offences.
ngaphansi kwezomthetho ku-section 174 ethizima ukudedela kumacala wonke abakade bamthosa wona-ke lapho-ke lasho khona ukuthi lesi isicelo siwela ngaphansi kwezomthetho lapho-ke u-section 174 ngaphansi kwezomthetho la eningizimu afrika-ke ngaphansi ku-act 51 ezomthetho ka-1977 lathi khona-ke ekugcineni kwecala-ke lozombuso-ke uma ngaba-ke khona-ke njalo-ke ulokuzana-ke bebona ukuthi abanalo icala lapho-ke komethi abasolwa-ke badedelwe-ke mana namcala lakade bebathosa wona-ke lapho-ke futhi abathole bengenawo kamacala-ke futhi washo khona njalo ukuthi uma befunda lapho background ngaphansi kwe-background lapho-ke bathi khona kanjalo umuntu washona-ke lapho-ke uSenzo Meyiwa-ke kade saziwa kakhulu njengomdlali webholo-ke futhi edlala njengo-goalkeeper-ke lapho-ke futhi umdlali futhi edlala ngaphansi kwamabhale futhi edlala iqembu le-Orlando Pirates futhi edlala ngaphansi kuyona-ke Premier Soccer League futhi neqembu lana-ke eNingizimu Afrika-ke lebafana-ke bathi wadutshulwa-ke wadutshulwa emzini we-ex-girlfriend yakhe usho intombi-ke kade athandana nayo-ke lapho-ke uKhili Khumalo ngelanga lange-26 zakaOkthoba ngomnyaka 2014 ngesikhathi kade amvakashele khona-ke kumuzi wakhe-ke lapho-ke bathi futhi ngelanga lange-16 zakaJuni ngomnyaka ka-2020 khona-ke njalo-ke ithimba labaseshi-ke lapho-ke kade laholwa-ke lapho kuBrigadier Geninda-ke ilona-ke osebenza ngaphansi ngaphansi kwama-cold cases wabopha khona njalo ebopha khona lapho-ke ubongani Ntanzi-ke okumsola wesibili-ke lapho-ke bese ngelanga lange-19 zaka-June ngomnyaka 2020 lapho-ke umsola wesibili-ke bese wabhala-ke statement noma wenza-ke confession-ke eyenza ngaphansi kwe-commissioned officer ekukade ku-Colonel Rapado lapho-ke ngelanga lange-24 zaka-June ngomnyaka 2020-ke lapho-ke umsola wesibili bese wabuya futhi wenza i-confession yesibili-ke lapho-ke noma statement ngaphansi kwamanje-ke lapho-ke uMiss Grunje lapho-ke ekhuluma khona ngaphecelezi ngodaba le-confession lapho-ke la kade khona-ke futhi ngemuva kwalokho kuyitatimende zakhe azenzile lapho-ke kwagcina sekuboshwa khona-ke njalo lapho umsola wesine-ke lapho-ke bathi khona njalo-ke ngelanga lange-17 zaka-July ngomnyaka 2023 khona-ke lapho-ke icala lelaqala-ke phansi lahlala phansi laphuma bese lahamba lihlala khona njalo-ke bathi sekuphile-ke isikhathi seminyaka-ke emibili-ke icala likade likhunywa khona njalo-ke futhi icala likade belikhambisile mhlawumbe belikhangisa kumabonakude-ke lapho-ke balala-ke eNingizimu Afrika futhi ngisho nangaphesheya kwey'lwandle lapho-ke futhi nangaphansi kuma-print media basho khona njalo ukuthi-ke khona-ke kade khona-ke iy'ngqinamba ekade zikhona-ke lapho-ke ezenza ukuthi icala lingahlali ngesikhathi esanele mhlawumbe kade khona kuphazamisa phakathi kwicala leli-ke lapho-ke basho khona njalo ukuthi uma ngabe sesikhuluma ngesicelo lesi saka-section 174 khona-ke lapho-ke bathi khona njalo uma siqhathanisa phakathi kwicala lika-SF icala likambuso-ke futhi libhekane khona-ke lapho-ke nomurero bathi khona-ke kade lingareportiwe lapho-ke elalana-ke e-GP wathi ngaphansi kwe-case number u-A523/2015 date lange-22 zaka-January ngonyaka 2016 lapho-ke ummeli kade aqhathanisa nje kuphela kulelo cala leli nake icala leli sikulona-ke futhi kasho khona njalo ukuthi ngesikhathi bekafunda futhi washo khona njalo ukuthi ngaphansi kwezomthetho kawa-section 174 uma ngabe-ke umsola mhlawumbe umsola okuwesilisa noma wesifazane noma wesimame-ke lapho-ke lingenayo icala lokuthi aphenduleke lapho-ke lokhu kuvame ukuthi mhlawumbe kusetshenziswe-ke khona-ke lapho-ke ngaphansi kwento ekusuke mhlawumbe benayo ehlangothini lezombuso-ke lapho-ke.
The accused, including accused number 4, are charged with the following offences. Murder read with the provisions of section 51, subsection 1 in bracket of the Criminal Law Amendment Act 105 of 1997 as amended, and further read with sections 92 subsection 2 in bracket 94, 256, 261 of the Criminal Procedure Act 51 of 1977. In that upon or about the 26th of October 2014 and at or near Prosecutorial in the district of Boksburg, the accused did unlawfully intentionally kill Mr. Senzo Meyiwa, a 27-year-old male, by shooting him with a firearm. The provisions of section 51 subsection 1 in bracket of Act 105 of 1997 are applicable in that the murder was planned or premeditated. B, the death of the victim was caused by the accused in committing or attempting to commit or after having committed or attempted to commit robbery with aggravating circumstances, as defined in Section 1 of the Criminal Procedure Act 51 of 1977. C, the offense was committed by a person, group of persons, or syndicate acting in the execution or furtherance of a common purpose or conspiracy. Count 2, attempted murder. In that upon or about 26 October 2014, and at or near Prosecutorial in the district of Boksburg, the accused did unlawfully intentionally attempted to kill Zandile Lorraine Kumar, an adult female person, by shooting at her with a firearm. Count 3, robbery with aggravating circumstances as defined in Section 1 of Act 51 of 1977, read with the provisions of Section 51 subsection 2 of the Criminal Law Amendment Act 105 of 1997 as amended, and further read with sections 92 subsection 2, 94, 256, 261 of the Criminal Procedure Act 51 of 1977. In that upon or about 26 October 2014, and at or near Prosecutorial in the district of Boksburg, the accused did unlawful intentional assault Miss Kelly Kumalo and or Gladys Kumalo, and did with force and violence take a Samsung S4 cell phone, the property or in lawful possession of Miss Kelly Kumalo and or Gladys Kumalo, and did rob her of same, aggravating circumstances being present in that the accused made use of a firearm. The provisions of Section 51, subsection 2 of Act 105 of 1997 are applicable in that there is presence of aggravating circumstances. Count 4, contravention of Section 3 of the Firearms Control Act 60 of 2000, possession of firearm. In that upon or about 26 October 2014, and at or near Phosphorus in the district of Bosbeck, the accused did unlawfully and intentionally have in their possession a firearm to with a 9mm CZ model 75 with obliterated serial number without being in possession of a license to possess the said firearm. In respect of this count, the state alleges that the accused jointly possess a firearm which is the subject matter in this count. Count 5, contravention of Section 90 of the Firearms Control Act 60 of 2000, possession of ammunition. In that upon or about the 26th of October 2014, and at or near Phosphorus in the district of Bosbeck, the accused did unlawfully and intentionally have in their possession an unknown number or quantity of 9mm parabellum caliber ammunition without being in lawful possession of a firearm capable of firing such ammunition.
Kana ke basola ke tsosa kana macala alandelayo ke futhi ke nomsola wesine iqala uqala iqala ukubulala ke lapho ke elwela ngaphansi kwezomthetho ka section 51 subsection 1 kwezomthetho lana ke eNingizimu Afrika ke wela ngaphansi ko Act 105 of 1997 futhi uma siqhathanisa uma sihanjiswa neminyaka ezemithetho ke lapho ke ingaphansi ko subsection 92 subsection 2, 94, 256, 14 or 261, Criminal Procedure Act 51 of 1977. La bathi khona ke ngelanga la nge-20 bathi ngelanga la nge-26 October eduze nendawo se-Phosphorus ke lapho ke noma ngaphansi kwesigodi sase Bosbeck ke lapho ke bathi khona ke khona njalo umsolo abasola benza lokhu futhi ngongemthetho futhi ngenhloso ngesikhathi kade bebulala khona ke lapho ke uSenzo Meyiwa kade weneminyaka ke u27 futhi amashumi amabili nesikhombisa ke ubudala ke futhi wesilisa ke bathi ngesikhathi kade edutshulwa ke lapho ke ngesibhamu ke lapho ke bathi lokukula ke ngaphansi kwezomthetho ke lapho sika 51 subsection 1 Act 105 of 1997 ushuthi lapho ke ushuthi umuntu ushuthi lokubulala kwabo ke bahlela phansi noma bacabanga bese bahlela phansi ngesikhathi kade bekwenza ke lapho ke futhi abuya futhi aqhubeka khona zathi ukushona kukamufi ke lapho ke kwakuyimbangela ukuthi kade khona ke abantu abangena bese bebenza lokudlala lobugebengu kade babenza ngaphakathi ke lapho ke noma bezama ukuthi babambe inkunzi lapho ngesikhathi futhi bebamba ke inkunzi kade ephethe ikhali ke kubona ke bade kokwela ke inkunzi futhi ngaphansi ko section 1 wezomthetho ngeNingizimu Afrika ke like Criminal Procedure Act 51 of 1977 la bathi futhi khona ke njalo kusho lamacala ke la kade benziwe khona ke lo muntu oyedwa ke noma mhlawumbe iqembu ke labantu kade lisebenzisana lonkana ke ekuthizeni bafizikise lokuzana isifiso sabo sokuthi benze lokho mhlawumbe ukuhlela ke ukubulala ke lapho ke bathi cala lesibili ke lapho ke ukuzama ke ukubulala ke bathi ngelanga la nge-26 October ngomnyaka ka2014 duze nendawo yasePhosphorus noma ngaphansi kwesigodi sasePhosphorus bese ngaphansi kwesigodi ngaphansi kwendawo yaseBosbeck ke lapho ke bathi ke abasola mhlawumbe kumsola wenza lokho ngengemthetho futhi ngenhloso ke la kade zama khona ke ukubulala khona ke lapho ke uZandile Lorraine Khumalo ke okade kuumuntu wesimama ke omdala ngesikhathi kade bemdubula ke bemdubula bese kade kusetshenziswa ke isibhamu ke lapho ke bathi futhi icala lesithathu ke lapho ke ukubamba inkunzi ke lapho ke niqhobile mhlawumbe bephethe ke ikhali kinina ke ezinobungozi ke lapho ke bathi sikhona ke lokho kukhulunywa ngaphansi kwezomthetho zaka section 1 Act 51 of 1977 futhi ifundeka nezinye ke zemthetho ke lapho ke section 51 subsection 2 yezemthetho lana ke eNingizimu Afrika ke lapho ngaphansi kwezomthetho zaka Act 105 of 1977 futhi uma sejobelelwa ke ihambisana ke nezinye neminye ke imithetho ke lapho ke isizohamba ke no section 92 subsection 2 section 94 section 256 futhi no section 261 yezemthetho lana ke eNingizimu Afrika ke wela ngaphansi kwezomthetho ke 51 of 1977 laba thi khona ke ngelanga la nge-26 October ngomnyaka 2014 eduze nendawo noma ngaphansi kwendawo seFosforasi ngaphansi kwesigodi saseBosbek khona-ke lapho-ke la khona-ke abasolwa benza khona-ke ngokungemthetho futhi nangenhloso-ke ngesikhathi kade bezama khona-ke lapho-ke ukuthizeni besenza lokhu kade bekwenza kulapho kuMiss Kelly Khumalo noma uGladness Khumalo ngesikhathi kade bemphoqa-ke lapho-ke noma ngokungemthetho bemthathe lapho kumakhalekhukhwini wakhe-ke kade kuyi-Samsung S4 cellphone yakhe-ke lapho-ke futhi kade kuyeyakhe-ke bayithatha ngaphandle kuthina-ke abavuma ukuthi bayithathe-ke lapho-ke bamba-ke inkunzi lapho-ke uKelly Khumalo noma uGladness Khumalo-ke lapho-ke ngesikhathi kade nithatha lokho futhi kade nisebenzisa nakhe lapho-ke izikhali ngesikhathi kade nisenza lokho-ke bathi lokho khona-ke ngaphansi kwezomthetho zaka-section 51 subsection 2 act 105 of 1977 ezomthetho shuthi lapho-ke iyangenelela phakathi-ke lapho-ke la bathi khona-ke nina kade nisebenzisa-ke izikhali ngesikhathi kade nisenza lokho-ke bathi icala lesine nibukene nalo-ke icala lokutholakala-ke niphethe-ke isibhamu icala lwela ngaphansi kwezomthetho-ke noma kungahambisani nomthetho ka-section 3 umthetho wezibhamu-ke lapho kwela ngaphansi ko-act 60 of 2000 sokunatholakala lapho-ke niphethe-ke isibhamu ngangemthetho-ke bathi ngelanga lange-26 zaka-October ngomnyaka 2014 duze nendawo noma ngaphansi kwendawo seFosforasi bese ngaphansi kwesigodi lapho sasebosbek bathi khona-ke abasolwa benza lokho ngongemthetho futhi ngenhloso-ke ngesikhathi ade bephethe khona-ke isibhamu kade kuyi-9mm CZ model 75 lapho kade inombolo zakhona-ke kade zicishiwe zingasabonakali kahle-ke kuleso sibhamu leso-ke nade nisiphethe futhi ngaphandle kokuthi liphethe-ke amaphepha akade enikeza imvume noma ilungelo ukuthi nisebenzise-ke isibhamu-ke lapho-ke bathi lokho-ke iyona-ke into ithimba noma ihlangothi lozombuso-ke abanishushisa ngayo-ke leyo-ke bathi futhi icala lesihlanu-ke lapho ukuthi nitholakale-ke lapho-ke ningahambisani-ke nomthetho ka-section 90 wezemthetho ezeyibhamu noma mhlawumbe izinhlamvu-ke lapho-ke ewela ngaphansi kwe-act 60 of 2000 la bathi khona-ke nina-ke ngelanga lange-26 zaka-October ngonyaka 2014 duze nendawo noma ngaphansi kwesigodi saseFosforasi bese ngaphansi kwesigodi noma ngaphansi kwendawo yaseFosforasi bese ngaphansi kwesigodi sasebosbek la kade nina-ke nenza ngokungemthetho futhi ngenhloso-ke lapho-ke ngesikhathi kade nitholakala niphethe khona-ke lokuzana iy'nhlamvu ey'ningi kunina-ke iy'nhlamvu lezo kade kuyinhlamvu zelokuzana ze-9mm parabellum caliber suthi isibhamu sakhona-ke leso-ke suthi lapho bathi inhlamvu zesibhamu leso-ke kade nitholakala niyiphethe lapho-ke futhi bathi inhlamvu lezo kade niphethe-ke inhlamvu ey'ningi ngendlela engajwayelekile noma engavumelekile.
The summary of substantial facts in terms of section 144 subsection 3 in brackets not letter A in bracket of Act 51 of 1977 details amongst others that there were several other persons in the house, namely Miss Gladness Khumalo, the owner of the house, who is the mother to Kelly, Miss Zandile Lorraine Khumalo, sister to Kelly, Mr. Longwe Twala, boyfriend to Miss Zandile Khumalo, Mr. Tumelo Madlala, friend to Mr. Senzo Meyiwa, and Mr. Mthokozisi Twala, a friend of Mr. Senzo Meyiwa in the lounge or dining room. A cell phone belonging to Miss Kelly Khumalo was taken and the assailant fled, dropping a head on the premises. It is important, my Lord, to mention that in respect of count 3 of the indictment, Ms. Kelly Khumalo was not called to testify despite being the complainant in that count.
Despite what?
Despite being the complainant in that count, in count number 3 of the
I thought there were
indictment.
2 complainants. Mr. Baloyi, is that not so?
Yes, indeed. The other complainant is the mother.
The mother, yeah.
Yes,
Yeah.
both of,
Okay.
in fact, I should say, my Lord, that both of them were not called before this court to come and testify about the circumstances of the robbery, which occurred on the 26th of October 2014 in the house in their presence. The state will allege that the accused were acting in the furtherance of a common purpose to commit the crimes as per the indictment. The duties of a prosecutor. In terms of Section 25 of the National Prosecuting Authority Act 32 of 1998, determines the powers, duties, and functions of prosecutors. Section 25, subsection 1, provides that a prosecutor shall exercise the powers, carry out the duties, and perform the functions conferred or imposed on or assigned to him or her, A, under Act 32 of 1998 and any other law of the Republic. B, by the head of the office or investigating directorate where he or she is employed or person designated by such head. Or C, if he or she is employed as a prosecutor in the lower court by the DPP in whose area of jurisdiction such court is situated or a person designated by such DPP.
kwezinto kade zikhona-ke lapho-ke shuthi mhlawumbe isihlahlamsindo-ke lapho-ke lathi khona-ke kade khona-ke abantu abaningi kade bekhona ngaphakathi kwalowo muzi walapho-ke futhi uqala kade akhona-ke lapho-ke bathi owesimame lapho uGladness Khumalo futhi yena-ke umnini muzi walapho-ke kulo muzi walapho kwaKhumalo-ke lapho-ke bathi wesibili kade khona kuZandile Lorraine Khumalo-ke kade kuwusisi kaKheli-ke lapho-ke futhi umnede kade kukhona-ke umnumzana uLongethwala kade kuyi-boyfriend noma sothi ushuthi umuntu ohlekisana noZandile Khumalo-ke lapho-ke futhi noTumelo Madlala-ke lapho kade kumngane kaSenzo Meyiwa futhi uMthokoziseni Thwala-ke lapho-ke naye kade kuwumngane kaSenzo Meyiwa lapho-ke athi bonkana labo bantu kade behlezi-ke lapho-ke kule ndawo yokuhlala shuthi mhlawumbe yokuhlala ngaphakathi komuzi-ke bathi ngesingisi-ke i-dining room-ke lapho-ke bathi ngesikhathi kade kusenzeka lokhu-ke kwathi khona-ke abantu ababili-ke lapho-ke abangena ngaphakathi kwalo muzi ngesikhathi kade bengena kade behlubile kubona-ke futhi bafuna-ke imali futhi nelokuzana namacingo-ke lapho-ke athi-ke lapho-ke ummeli-ke ukhumbule khona njalo-ke ukuthi bonkani labantu ekukhulunywa ngabo-ke lapho-ke thizeni madatha babakhuthuza lapho noma mhlawumbe babamba inkunzi-ke lapho-ke abakaze beze bazoletha ufakazi babo ngaphambi kwenkusenkantolo-ke lapho-ke futhi uyafunda manje uma uqhubeka efunda khona njalo lapho-ke mayelana nesikhangiso sakamshushisi-ke lapho-ke athi mayelana nezomthetho lapho section 25 owela ngaphansi kwezomthetho lapho National Prosecuting Authority lapho-ke Act 32 of 1998 uyasho khona njalo uyakhuluma ngendlela kumele abashushisi basebenze ngayo-ke uma besebenza mayelana phecelezi nozomthetho mayelana nodaba lozomthetho-ke lapho-ke athi ngaphansi kwe-section 25 subsection 1 iyona ekhuluma phecelezi ngodaba labashushisi ukuthi kumele basebenzise kanjani-ke amandla wabo-ke uma ngabe bephethe umsebenzi wabo besebenza lapho-ke phecelezi nodaba lamacala uma ngabe abashushisi-ke lapho-ke besebenza sithi mhlawumbe kwinkantolo-ke eyincane-ke lapho-ke noma besebenza ngaphansi nje kokuphenya kamacala noma ekusizeni amacala aphothulwe ngaphambi kwenkosi yenkantolo-ke lapho-ke noma besebenzela ngaphansi kwe-DPP-ke lapho-ke beyakhuluma ngodaba lolo-ke kuphela.
The prosecutor has a duty to pay attention to the contents of the police docket. In this regard, see Minister of Police and another versus Duplessis, 2014, Volume 1, SACR 217, SCA. The summary of substantial facts in terms of Section 144, subsection 3, in bracket, small letter A in bracket of the Act 51 of 1977, details that the deceased, Mr. Senzo Meyiwa, died during or after the commission of the robbery, which gone wrong. Brigadier Kininda, in his evidence, details a hit to kill the deceased and based this argument in the investigation done and or conducted by the investigating team on the following. The evidence of Colonel Lambertus Stein. Colonel Stein testified that he was employed by South African Police Service and in the service of the state, attached to the National Court Case Unit investigation based in Pretoria, National Head Office, where he acted as an analyst and an investigating officer. On the 9th of April 2020, at about 10 o'clock, he received a series of Section 205s and cell phone downloads from the investigating officer, Brigadier Kininda. He testified further that Brigadier Kininda requested him to determine if there are any linkages between the current suspects and the people in the house at the time of the crime. The transcribed record of the 27th of July 2023 at page 64, line 10 to 15 states the following. Mr. Stein, I just want to draw attention to the court that as well that a Section 205 information, not one of the team members applied for that, but it was stored on the central database of the police. So that is why it was being applied for by the previous investigation officers. But we did have access to that.
Safunda futhi phecelezi nodaba laka lapho-ke lokusebenza lapho-ke kwethimba labashushisi ke lapho-ke bese kuyaqhathanisa phakathi kwecala lapho-ke lika-Minister of Police futhi nabanye-ke lapho-ke no-DPLC lango-2014 volume 1 SACR 217 lapho-ke athi khona-ke njalo lapho-ke athi khona-ke udaba phecelezi bathanda khulume ngalo-ke lapho-ke uma ngabe khona kufakazi obukhethekile noma ufakazi obabukhethile nocaphulile ekuthizini enza aqhathanise phakathi kwabo-ke lapho-ke lathi khona-ke ubufakazi ade bukhulunywa lapho kumnumzana uColonel Lambert Stein osebenza ngaphansi kwezesiphoyisa-ke lapho-ke la bakhuluma khona ukuthi yena-ke ngesikhathi lesi ngelanga lange-9 zaka-April ngonyaka 2020 lapho ngehora laka-10 kusasa-ke wathola-ke ucingo lapho uqhamuka lapho ngaphansi kwe-section 205-ke lapho-ke zokuthwebula kwemininingwane ngaphakathi kwamacingo-ke lapho-ke la bacala khona kuBrigadier Gininda khona-ke lapho-ke athi ukuthi yena umsize ngesikhathi batestify lapho noma ngesikhathi beqeda athula ubufakazi bakhe-ke lapho-ke athi akabheke ukuthi noma ngesikhathi bamcetha akabheke ukuthi ngabe khona yini uxhumana phakathi kwalabantu bekhona ngaphakathi kwelamuzi yini-ke ngesikhathi salo bugebengu lobu-ke lapho-ke bese-ke yacaphula ngaphansi kokushicilelwa inkantolo ngelanga lange-27 zenyanga kaNtulikazi ngonyaka 2023 lapho kwikhasi le-64 lapho kumugqa wesi-10 kuze kufince kumugqa wesi-15-ke lapho-ke la umnumzana uStein wakhuluma khona-ke lapho-ke ekuthizini wacelwa njalo akadwebeke lapho kusebenza kwakhe noma ukusebenza ngaphansi kwenkantolo-ke lapho-ke ngaphansi komthetho section 205 lapho-ke nemininingwane kade anayo lapho-ke futhi ecelwa amaphoyisa-ke lapho-ke ekuthizeni enze lolo daba-ke lolo mhlawumbe lo cwaningo lomsebenzi-ke lapho-ke athi lonkana locwaningo kade beshicelele ngaphansi kwe-database yezesiphoyisa-ke lapho-ke athi khona-ke njalo futhi leso sicelo kade sisenziwe lapho-ke umseshi wecala lapho-ke ngesikhathi kade esikusenziwa lokhu-ke khona njalo-ke.
Then my next point, during my analysis, I discovered that Kelly Kumalo with number 278270444358, she received a call from Ntulinkani with number 2773305923. This appears from the transcribed record of the 27th of July 2023 at page 75, line 6 to 9. According to Colonel Stein, communication between the two numbers occurred on two separate occasions. That is on the 2nd of August 2014 and 15 October 2014. The details of the communication are reflected on page 23 of Colonel Stein's affidavit, Exhibit 01. It is important, my lord, to mention that the information from the central database of the South Police Services was editable, and the state did not call any witness to authenticate it during the course of this trial. The state, by this communication, that is communication between the two numbers, intended to prove communication between the mastermind, which according to the brigadier, that is Brigadier Gininda, was Miss Kelly Kumalo and accused number 5. Accused number 5 then procured the services of his co-accused, that is accused 1 to 4, in the execution of the murder. The evidence of Miss Pinky Vitilingam.
Lapho sibasho khona njalo kwecaphula kunkulumo kade khona lapho umnumzana ke uStein lapho ke ngaphansi kwekhasi lama-23 ke lapho ke la ecapha khona ke khona ke njalo yena ke into umsebenzi kade awuceliwe ekuthizeni ke awenze lapho ukuthi agqinize kabanzi ekuthizeni enza ama-analysis ke lapho ke phecelezi nodaba phakathi kwakaKelly Kumalo ke kwinombolo zakaKelly Kumalo ke lapho ke ezihamba ngalo 082 7044 358 lezi athola khona ucingo kuzona ke kade qhamuka lapho ke kuNtulinkani futhi naye kade enale inombolo ezilandelayo ke lapho ke kade ku 0733059202 lapho khona lokho kade kukhona kushicilelwe ngelanga lange-27 ngenyanga kaNtulikazi ngonyaka 2023 lapho ke ngaphansi kwepage lapho ke noma ikhasi le-75 uqala kumugqa wesithupha kuze kufince kumugqa wesi-9 ke lapho ke lathi khona ke njalo ngamalana nodaba lwaka-Colonel Stein lathi khona ke kodwa khona ke ukukhuluma phakathi kwabantu ababili kade kusenzeka lapho-ke futhi amahlandlo amabili-ke lapho-ke futhi ihlandlo lokuqala noma isikhathi sokuqala kungelanga lange-2 zaka-August ngomnyaka 2014 bese-ke ilanga lesibili-ke lapho-ke kade kuyilanga lange-15 zaka-October ngomnyaka 2014-ke lapho-ke yonkana le mininingwane iyona-ke ngaphansi lapho-ke noma inkulumo yabo-ke kade khona-ke ngaphansi kwe-page 23 laka-Colonel Steyn ngaphansi kuyafidavit kade ayibhalile ewela ngaphansi kuka-exhibit O futhi washo khona nje athi ihlangothi ithimba lakhe lapho-ke noma into kade ithimba leziphoyisa kade lenza-ke lapho-ke ukuthi ixhumanise-ke abantu laba bonkana futhi-ke phecelezi nodaba lenkulumo iqhamuka kuhlangothi lwezombuso-ke lapho-ke ukuthi baqhamukise ukuthi kade khona-ke inkulumo kade khona phakathi kwalabantu bonkana noma lo muntu kade aqashile-ke abantu laba-ke futhi nomsola wesihlanu-ke lapho-ke futhi nabanye-ke abanye kade besebenzisana naye-ke umsola wesihlanu-ke lapho-ke umsola wokuqala kuze kufike kumsola wesine-ke lapho-ke ekuthizeni baphumelelise lokhu bulala lokhu.
In fact, the Section 205 records from Vodacom depicts a different scenario with regards to the communication that Colonel Steyn testified about. It details that, in fact, Ms. Kelly Kumalo with the number 278270444358 had received calls from Mr. Arthur Mufokate and the deceased on the 2nd of August 2014 and 15 October 2014, respectively. The evidence of Ms. Pinky Vitilingam. I submit, my Lord, that there were discrepancies between the analysis of Section 205 records analyzed by Colonel Steyn from the central database of the South African Police Service and the extracts of the Section 205 records, that is Exhibit J1. Ms. Pinky Vitilingam could not give an account of such discrepancies. She could only state that she could only testify about the Section 205 records from Vodacom, which depicted, as I've said earlier, my Lord, the communication on the 2nd of August 2014 and 15 October 2014 between Mr. Arthur Mufokate and the deceased Mr. Senzo Meyiwa to Ms. Kelly Kumalo. The data cell phone records do not disclose such communication between Ms. Kelly Kumalo and accused number 5 before this court. The SMSs between Ms. Kelly Kumalo and her sister Zandile Kumalo that reveal the following. In this regard, see page 6 to 12 of Exhibit 01. The trial commenced through the witnesses' evidence who were inside the house when the incident occurred, painting a picture of the robbery gone wrong. But when the trial progressed, it built around the assassination of the deceased. Brigadier Gininda described Ms. Kelly Kumalo as the mastermind and the trigger point in the execution of the deceased murder. And to that extent, Brigadier Gininda, applied for a warrant of arrest against Ms. Kelly Kumalo, which was never executed. As he says, it was a prosecutorial-driven investigation. I'm well aware, my Lord, that the state is not bound by the summary of substantial facts, which means that the evidence not disclosed therein or which differs from it will not be inadmissible on that ground alone. In this regard, see State versus Conference at page 21, paragraph D to F. The court will nevertheless, in the evaluation of the state case, compare the evidence given with what the state indicated its case will be. See State versus Holoko 1991, volume 2, SACR 203, capital letter A in bracket, at page 207, paragraph B to C. It follows that it is therefore crucial for the state case to indicate that the accused entered into an alleged conspiracy agreement with Ms. Kelly Kumalo. Failing such proof, the accused, that is accused number 4, cannot be convicted on any of the first 3 counts against him, and accordingly not on the 4th or 5th count.
La bekasho khona njalo kuphecelezi nodaba laloko lofakazi kade kuhamba lethu umama lapho ke uPinky Vitsi lathi khona-ke njalo khona-ke kade khona-ke phecelezi udaba lwezomthetho lapho ka-section 204 kade khona-ke lapho-ke ukungahambi kahle futhi amaphutha amaningi-ke lapho-ke phecelezi nodaba lakwamnumzana uCornel Steele uma iqhathanisa lona-ke nodaba loqhamuka lapho ngaphansi kwe-Vodacom usho ukuthi uCornel Steele nako uqhamuka ngaphansi kwe-database noma wasebenzisa-ke lapho-ke i-database ezesiphoyisa-ke ngesikhathi kade senza lokhu-ke wacapha kuyona-ke i-section 205 yakhe-ke lapho-ke bathi kokhona-ke kwemibukiso lapho-ke ka-exhibit J1 futhi nalena kapinki-ke lapho ukuthi kade noma kade bengakhulumeli-ke ngayo-ke lapho-ke la bathi khona-ke shuthi kade ngakho-ke ilukuzana i-data cell phone record lapho-ke esho khona njalo kade khona-ke inkulumo phakathi kokheli Khumalo-ke lapho-ke nomsola wesihlanu-ke lapho-ke athi futhi noma ngakho futhi idaba lwama-SMS-ke lapho-ke kade khona phakathi kokheli Khumalo nosisi wakhe lapho uZandi Khumalo oluqhamukile lapho-ke futhi washo khona njalo kumele sibuke lapho-ke ngaphansi kwesikhathi lesithupha kwezinye kwesikhathi le-12-ke lapho-ke ngaphansi kwemibukiso-ke lapho-ke ka-exhibit 01 lapho-ke futhi ngesikhathi icala leli-ke noma ngesikhathi icala behlezi likhulunywa phambi kungasenkantolo lapho-ke athi khona-ke kade khona-ke abantu kade khona ngaphakathi kwala muzi-ke lapho-ke futhi bona abadoba isithombe-ke khona-ke lapho-ke basho khona njalo ukuthi kade khona-ke abantu kade befikile lapho-ke bobamba-ke inkunzi-ke kepha lokho kaze igcine kube sekubanjwa-ke inkunzi-ke lapho-ke kepha bagcina sebahlasela futhi bagcina bebulala-ke khona-ke lapho-ke umufi-ke lapho-ke futhi athi uBrigadier Gininda naye uyena ochazile kabanzi lapho-ke athi ukheli Khumalo uyena-ke umastermind usho ukuthi yena-ke umuntu odlala-ke isikhangiso sokuthi lelokozana-ke usho ukuthi uyena kade ekhona phakathi nendawo ngesikhathi kade senzeka lokhu phakathi kwabasola futhi nomufi-ke lapho-ke bathi uBrigadier Gininda washo ukuthi kukhona-ke incwadi kade ecelile lapho-ke noma isicelo sencwadi kade asenza lapho-ke ukuthi lapho kokheli Khumalo-ke aboshwe-ke lapho-ke kepha lokho bathi akaze kwenzeke-ke ngoba impindo yakhe kukuthi lapho-ke ngesikhathi bekasesha icala leli futhi bekasebenzisana-ke nethimba labashushisi-ke lapho-ke futhi eqhubeka washo khona njalo mayelana nesamari yakhe lapho-ke ummeli wenu-ke kade akhuluma ngalo yofakazi umhlaba ufakazi athi bukhona-ke lapho-ke wathi lokhu futhi yinto engekho futhi nanoma ekhuluma ngayo futhi-ke wabuya futhi waqhathanisa phakathi kwecala leka-Van Feren lapho-ke ekhuluma ngaphansi komugqa wesi-21 noma ngaphansi kwekhasi lesi-21 iqala paragraph D2F lapho-ke akhulume khona njalo futhi nangelinye icala lombuso ngesikhathi umbuso ubhekene icala lakaHoloho lapho-ke laka-1991 volume 2 CCR 203 lapho-ke akhuluma futhi nangolunye-ke udaba-ke lapho-ke futhi ubuyile wakhuluma khona njalo kuwukuthi lapho-ke lokhu akukho la ithimba labashushisi noma ithimba lozombuso-ke noma ihlangothi lozombuso la iqhamuke khona-ke nenkulumo kade khona-ke phakathi kwabantu labo-ke futhi abasolwa-ke lapho-ke noma inkulumo eqhamukile kusho ukuthi iyona-ke vele ebambekayo nesihlahla futhi nomsindo-ke lapho-ke abathi-ke la bathi khona-ke abasola bonkana futhi nokheli Khumalo kade bekhuluma khona-ke bonkana bephelele-ke futhi asho khona njathi umsola lapho-ke akangabekwa-ke amacala ngalokhu konke-ke akwenzile-ke noma lokhu bamthwesa ukuthi ukwenzile engakwenzanga futhi amacala wonkana womathathu futhi necala lesine futhi icala lesihlanu.
The legal position, I've referred to the provision of Section 174 of the Act. The corollary is that he ought to be acquitted. That is the accused, if it is reasonably possible true that he might be innocent. My own emphasis. The word no evidence in Section 174 of the Act means no evidence upon which a reasonable person might convict the accused, as stated by Ramsey J. Instead versus Kanyapa, 1979, Volume 1, SA 824, capital letter A in brackets, at page 834, paragraph F. It is well established that no evidence does not mean no evidence at all, but rather no evidence on which a reasonable court acting carefully might convict. The question whether a court should grant the discharge at this stage is one which entails a discretion by the trial court. It is a discretion which must self-evidently be exercised judicially.
ngaphansi kwezomthetho-ke lapho-ke la ekhuluma phecelezi nodaba luka-section 174 lapho isicelo sathi aqhamuke ngaso-ke lapho-ke lathi khona ekugcineni kwecala lezombuso-ke lapho-ke kwamele ukuthi khona-ke njalo lapho-ke uma ngabe-ke abantu bebona ukuthi kanjalo abanalo icala phecelezi nabo kwamele balethe isicelo lesi-ke lapho-ke athi futhi kwamele ukuthi inkantolo uma ibabona bengenalo icala kwamele ukuthi badedele-ke ngoshweleke lapho noma ibadedele nje kuphela-ke lapho-ke wathi washo khona njalo lapho-ke nanoma kusho lokhu-ke athi ngaphansi kwezomthetho zika-section 174 lokhu akusho ukuthi ubufakazi lapho-ke abukho-ke lapho-ke ubufakazi obukhethekile ubufakazi obubambekayo lapho-ke obungaze buphoqelele ekuthizeni-ke abasuke bagcine lapho-ke bethoswa-ke icala-ke lapho-ke futhi obeyaqhathanisa phakathi icala lapho lika-Ramf CJ futhi icala libhekene necala lozombuso-ke lapho-ke noma icala likaKhanyapa laka-1979 SACR SA 824 lapho-ke A futhi washo khona njalo lapho-ke kwamele lokhu kubhekwe futhi kubhekisiswe kahle-ke lapho-ke uma ngabe ufakazi lokhu kade ufakazi obukhethekile mhlawumbe ufakazi obubambekayo noma ufakazi obubambekayo okunesihlahla noma ufakazi obunomsindo lapho bungekho khona-ke kwamele ukuthi lapho inkosi yenkantolo mhlawumbe inkantolo lokhu isebenze ngendlela ekhethekile futhi ngendlela ejulile lapho thizeni-ke idedeleke abantu-ke lapho-ke kumacala ade bathosa wona-ke.
The judicial pronouncement on the manner in which the trial court must exercise its discretion has been contentious. I do not intend to give a full historical overview. I will confine myself to a brief reference to those cases that help to define the scope of the court's discretion in terms of Section 174. In State versus Shopping and others, 1983, Volume 2, SA 119, capital letter B in bracket. The IMSTRA CJ reviewed the case law history of discharge application and formulated the test as follows at 120 to 121, capital letter A. And I quote, at the close of the state case when a discharge is considered, the first question is Roman figure 1. Is there evidence on which a reasonable person might convict? If not, Roman figure 2. Is there a reasonable possibility that the defense evidence might supplement the state case? If the answer to either question is yes, there should be no discharge and the accused should be placed on his defense. Close quotation. There is criticism in respect of the second test in the Shopping case. And the criticism labeled was referred to in State versus Lubaka 2001, Volume 2, SACR 702 SCA inter alia, as follows. At paragraph 14, the criticism of Shopping's case relates to the second leg of the inquiry, which permits an accused person to be placed on his defense, even when there is no case to answer, merely in the expectation that the defense evidence might supplement the prosecution's case. To place the accused on his defense in those circumstances has usually been said to be in conflict with the presumption of innocence. Close quotation.
phakathi kwelinye-ke icala selahlalela ngaphansi kwenkosi enkantolo-ke lapho-ke lecala kade akhuluma-ke ngalo-ke lapho-ke Shopping futhi nabanye-ke lapho-ke kahle lapho-ke na-M3 ijaji yakhona-ke lapho-ke nkuluma inkosi enkantolo-ke lapho-ke lathi khona-ke egcineni kwecala noma qhathanisa phakathi kwesicelo sakhe lesi futhi nesicelo secala leli eda-ke khuluma-ke ngalo-ke qala.
In State versus Lubata 2001, Volume 2, SACR 703 SCA, the following was said. The right to be discharged at that stage of the trial does not necessarily arise, in my view, from consideration relating to the burden of proof or its concomitant, the presumption of innocence, or the right to silence, or the right not to testify, but arguably from the consideration that more general application. Clearly, a person ought not to be prosecuted in the absence of a minimum of evidence upon which he might be convicted, merely in the expectation that at some stage he might incriminate himself. That is recognized by the common law principles that there should be a reasonable and probable cause to believe that the accused is guilty of an offense before a prosecution is initiated. See Beckenstrater versus Rota and Tiernesen, 1955, Volume 1, SA 129, capital letter A in bracket, at page 135, paragraph C to E. And the constitutional protection afforded to dignity and personal freedom in terms of Section 10 and 12 of the Constitution seems to reinforce it. It ought to follow that if the prosecution is not to be commenced without that minimum of evidence, so too should it is when the evidence finally falls below that threshold. That is preeminently to be so where the prosecution has exhausted the evidence and the conviction is no longer possible except by self-incrimination. A fair trial, in my view, will at that stage be stopped, for it threatens thereafter to infringe other constitutional rights protected by Section 10 and Section 12 of the Constitution, close quotation.
Qhathanisa phakathi kwecala lapho ke likambuso futhi icala likalubaxaka lapho icala lango-2001 ngaphansi sokuthi volume 2 lapho ke CCR 703 lapho icala ka-inter ali lapho ke bayakhuluma phecelezi ngodaba lolu ke lesicelo sakhe sokuthizeni ababusoro babadedeleke noma umsoro abadedeleke lapho ke bangamthwisa icala ngaphansi kuwonkana amacala ade bemthwesa wona ke lapho ke yilokhu nje kuphela kade kubalekile bekakhuluma ngakho uqhathanisa phakathi icala leliyana eselahlala ngaphambi kwenkosi enkantolo ngesikhathi nesindlule futhi icala lelakho lamanje.
It has in hand that the credibility of state witnesses at this stage of the proceedings only play a very limited role. In State versus Mpeta and others, 1983, Volume 4, SA 262, capital letter C at 265 D to G, Williamson J. held that relevant evidence can only be ignored if it is of such poor quality that no reasonable person could possibly accept it. Close quotation. Therefore, to summarize the legal position regarding application in terms of Section 174 is as follows. An accused person is entitled to be discharged at the close of the case for the prosecution if there is no possibility of a conviction other than if he enters the witness box and incriminates himself. B. Credibility of witnesses' evidence is only an issue where it has been the effect that the evidence is so unreliable that it can be said that no evidence has been adduced. C. Where the evidence of the state witnesses indicating the accused is of such poor quality that it cannot be relied on, and there is accordingly no credible evidence on record upon which a court acting carefully may convict, an application for a discharge should be granted. D. An acquittal must be in the interest of justice. E. Circumstantial evidence in the state case may be relevant factor in deciding whether a case against the accused is so strong that it calls for a reply in the witness stand. It is against this legal background that I find it prudent to refer to the portions of the evidence of Zungu in the record of the proceedings and later proceed to analyze his evidence. Constable Sizwe Sikumbuzo Zungu testified that he was a constable employed by the South African Police Services with 12 years experience under the invisible policing station at Sebenza Police Station. He knows all the accused before court. He knew Mthokoziseni accused number 4. He remembers him from Phosphorus, but not back home. On the 26th of October 2014, he received a call from Gwabeni. Gwabeni wanted to know him, from him, that is Zungu, whether he was able to come to Phosphorus on that day. He responded that it was still early because it was around 7:15, and that on that day he was still going to work. Gwabeni called him again and informed him that there was another brother of ours, Makosonke from Rustenburg. He informed him that Makosonke was also going to be joining us. He knocked off and contacted Makosonke Zungu He informed him that he was at Johannesburg at Carlton Center. That is where he will find him. He went there and found him. They arrived at a hostel between 2 to 3. He will not be able to remember the exact time.
lapho ke kade afunda phecelezi nodaba lolu-ke futhi washo khona njalo uma ibuka lapho icala lapho-ke lezombuso kade lapho lihlelwe inkosi yenkantolo lapho-ke uhomuke lapho-ke futhi icala lezombuso phakathi no-Aglito lango-2011 volume 2 lapho-ke CCR 437 lapho-ke beyakhuluma phecelezi nodaba lolu-ke lokuthi khona-ke lapho-ke uma ngabe icala seliphethe emaphethelweni-ke lapho icala lezombuso-ke lapho-ke uma ngabe-ke umsolwa lapho-ke ngafisa ukwenza lokhu okulandelayo ngaphansi kwezomthetho-ke unakho ukuthi akwenzeke lo sicelo sakhe sikhethekile lapho-ke lathi khona-ke umsolwa khona-ke njalo uvumelekile futhi unakho ukwenza lokhu-ke egcineni kwecala lezombuso lapho-ke ekuthizeni aqhamukise nesicelo sakhe lapho-ke noma mhlawumbe abize abofakazi bakhe-ke lapho-ke noma ngene ngaphakathi kwebhokisi lapho-ke bese ayikhulumele noma mhlawumbe-ke lapho-ke azifake yena-ke mathupha-ke ecaleni-ke lapho-ke athi lapho-ke uma ngabe sibuka futhi bofakazi ade bekhona-ke lapho-ke uma bengenaso isihlahla mhlawumbe isihlahla msindo lapho-ke kwamele ukuthi abasolwa lapho babadedele bababone futhi bengenacala lapho-ke wathi lokhu kukhona wathi lokhu kukhona uma buka phaka icala lapho-ke likambuso futhi noSwartz lapho-ke lango-1999 volume 1 lapho-ke CCR 319 lapho-ke open bracket besathi W lapho-ke noma ukuthi lapho ubufakazi bezombuso lapho-ke nomhlaba noma abofakazi bezombuso lapho uma belethe ufakazi obungenasihlahla msindo noma ubufakazi lapho mhlawumbe-ke obungahambisani-ke lapho-ke noma ufakazi lapho mhlawumbe obuphuka-ke lapho-ke obungenayo-ke lapho-ke isihlahla msindo okubonayo-ke lapho ufakazi obumayelana nalolu daba lolu-ke athi kwamele inkosi yenkantolo lapho-ke ingagwebiki abasolwa noma engabatholi-ke abasolwa benicala lapho-ke kwamele futhi ekuthizeni ibavumele uma ngabe sebeletha isicelo sabo sokuthi babadedele ngaphansi kwamacala wonke akade bebathusa wona-ke lapho-ke wathi ku-D lapho-ke usho ukuthi lapho lokhu kumele ukuthi bakwenze ngaphansi kwezomthetho noma ngaphansi kwezamalungelo ezomthetho-ke lapho-ke futhi wabuya washo khona njalo-ke lapho-ke wathi mina nofakazi bethimba lwezombuso loba abathi bona-ke banabo lapho-ke kwamele ukuthi inkosi yenkantolo futhi ibukisise futhi ibuke ngendlela ekhethekile futhi ngendlela-ke ejwayelekile engabuke ngendlela engajwayelekanga abofakazi lapho-ke kade bekhona-ke lapho-ke bese qhathanisa phakathi kwecala lezombuso-ke lapho-ke nocele lango-1986 volume 2 PHH 121 futhi washo khona njalo lapho-ke uma ngasesilapha ku-background-ke lapho-ke sithi abofakazi ade bekhona-ke lapho-ke bathi khona-ke ufakazi othizeni-ke lapho-ke okade bekhona ufakazi bakhe okade ekhona ngaphambi kwenkosi-enkantolo-ke lapho-ke bese washicelela ufakazi bakhe lapho-ke bathi uZungu bathi khona kwento ayikhuluma ngaphakathi kwenkosi enkantolo-ke ngesikhathi bekalana-ke washo khona njalo yena-ke uconstable Sizwe Sikhumbuzo Zungu-ke lapho-ke ngesikhathi bekathula ufakazi bakhe-ke lapho-ke washo uconstable futhi usebenza ngaphansi kwezesiphoyisa-ke wathi uneminyaka eyi-12-ke isipiliyoni esebenza ngaphansi kwezesiphoyisa-ke futhi usebenza ngaphansi kwezesiphoyisa sasesebenza police station-ke lapho-ke futhi washo yena ukuthi bonkana abasolwa uyabazi labathe bekhona ngaphambi kwenkosi enkantolo-ke futhi wathina uMthokoziseni wamazi njengomsolwa wesine-ke lapho-ke ngesikhathi bekaqala kumbona lapha eFosforasi-ke kepha kanawo umkhumbulo wakhe wasemakhaya-ke athi ngelanga lange-26 October ngaka 2014 nakathola ucingo kade liqhamuka kogwabeni bathi ugwabeni uyena-ke owazisa-ke uZungu noma watshala-ke uZungu okuwukuthi kwamele ukuthi afike eFosforasi ngalo-ke lela langa lelo-ke bese uZungu waphendula wathi yena-ke wabamshayela ngesikhathi sakusasa samahora kusasa-ke athi nge-7 yakusasa-ke lapho-ke yena futhi bekazokuselela kuya emsebenzini ngesikhathi bekashayela lapho-ke bathi ugwabeni-ke nawe uyena-ke wamtshela khona njalo ukuthi khona-ke omunye umfowabo-ke lapho-ke noma umfowabo lapho-ke kade kwabathi uMakhosonke-ke baqhamuka ngaphansi noma kade aqhamuka-ke Rustenburg-ke uMakhosonke lapho-ke bathi wamtshela ukuthi uMakhosonke khona-ke naye futhi uzofika abajoyine-ke noma hlanganele nabo endaweni eyodwana-ke lapho-ke bathi yena-ke washayisa-ke emsebenzini ngesikhathi beshayisa emsebenzini-ke bese wathinta-ke uMakhosonke-ke leZungu-ke lapho-ke wamtshela kumele bahlangane lapho-ke eGoli eduze nase-Cartoon Center noma e-Cartoon Center-ke lapho-ke athi kukhona iyona ndawo bekazomfica kuyo-ke ngeleyo-ke uma ngabe sekashayisile emsebenzini-ke athi empeleni ngangeqiniso ogcina befika-ke lapho-ke hostele ngemuva kwehora lesibili noma ngehora lesithathu kade engasakhumbuli kahlehle ukuthi ngabe wafika ngasiphi-ke isikhathi lapho-ke.
It is against this background that I will proceed and analyze Zungu's evidence. According to the version of the state, the only witness who met and placed the accused at Phosphorus Hostel on the 26th of October 2014 was Constable Zungu, Constable Sizwe Skhumbuzo Zungu, who was a single witness. It is straight law that a court should approach the evidence of a single witness with caution. The following passage from the judgment of the Phyllis J.P. in R. vs. Mokoena, 1932 OPD 79 at page 80 is frequently cited. I quote, "The uncorroborated evidence of a single competent and credible witness is no doubt declared to be sufficient for a conviction. But Section 284 of Act 31 of 1917, that is the predecessor to Section to the Act 51 of 1977. But in my opinion, that section should only be relied on where the evidence of a single witness is clear and satisfactory in all material respects." Close quotation. In State vs. Weber, 1971, Volume 3, SA 754, capital letter A in bracket, the Appellate Division stressed that there was no magic formula which determines when the evidence of a single witness testimony may warrant a conviction in every case. What may be said, however, is that the evidence of a single witness has to be approached with caution. His or her merits as a witness must be weighed against factors which militate against his or her credibility. Thus, the mere fact that he or she has an interest or bias against the accused will not of itself obviate a conviction. It is necessary to assess the intensity of the bias in the light of the totality of the evidence. Close quotation.
Uyena ufakazi oyedwa kuphela lona-ke kade ubeka-ke abasolwa ngaphansi kwendawo se-Phosphorus lapho-ke wathi ufakazi lo-ke uConstable Sizwe Skhumbuzo Zungu-ke owasukhaza ukuthi mina-ke kade likhona-ke lapho-ke lokuzana lapho-ke ke futhi obuye washo khona ukuthi ethimba lozombuso futhi nenkantolo-ke lapho-ke akumele ukuthi lapho-ke uma sebuka kufakazi babuke kufakazi bofakazi oyedwa-ke osho ukuthi ufakazi oyedwa-ke loyo-ke osuke esikhathini esiningi-ke ebeka-ke labantu abasolwa-ke ngaphansi kwendawo yesigameko-ke noma ngaphansi kwendawo ekhethekile noma ngaphansi kwendawo ethizini-ke lapho-ke ngoba bathi lokho esikhathini esiningi usuke akwenza ngokuthi na-ke mhlawumbe unento-ke mhlawumbe susho ukuthi mhlawumbe angayithandile kubona mhlawumbe engahambisani-ke nabo-ke noma mhlawumbe eyenza lokhu ekwenza lokhu-ke ngokuthi ufuna ukuthi abantu ababesuthi mhlawumbe abacekela phansi-ke lapho-ke noma futhi bababone-ke benecala-ke abantu labo-ke bathi kusenkantolo kwamele ukuthi lokhu kubuke futhi ngendlela-ke ekhethekile futhi ngendlela-ke ejulile.
Corroboration. In State vs. Jangley 2005, Volume 1, in bracket SACR 420 at 430, QTJA in dealing with the approach to be followed by a court when it is faced with a situation where a court should caution itself in analyzing the evidence said the following, I quote, "It must be emphasized immediately that by corroboration is meant other evidence which support the evidence of the complainant and which renders the evidence of the accused less probable on the issue in dispute." Close quotation. It is clear from the authorities that if corroboration was required, if it had, for purposes of the so-called cautionary rule, to be corroboration implicating the accused, and not merely corroboration in the material respect or respects. The evidence of Zungu was not corroborated in all material respects. Skhumbuzo Zungu was not called by the state to corroborate the version of Zungu, insofar as traveling with Zungu to the hostel after he had received a call from Gwabeni to pick up Skhumbuzo Zungu at Carton Center in Johannesburg. Zungu is the only witness who met the accused at Phosphorus Hostel. He was introduced to the accused by Gwabeni. It is surprising that this introduction was done to this witness when Zungu and the accused knew each other. Zungu testified that he was requested by a certain gentleman, that is accused number 5, was requesting him to remove his vehicle because he had parked behind the vehicle that accused number 5 was traveling. Zungu and others he was seated with went to buy liquor, and they drove using an Uno motor vehicle. He was traveling with accused 2, accused 3, and the driver. There were 5 in total. From the body of Zungu's evidence, this is the only time that he had traveled with accused 2 and accused number 3.
Lapho ukuthi kade afunda khona ke phansi but ufakazi lokho kade buhambisana ke lapho ke athi lokho sibuka ngaphansi uma eqhathanisa kumacala ke lapho ke icala lapho ke lozombuso ke libhekene icala lapho lika Gentile 2005 ke lapho ke volume 1 ACCR 420 ke lapho ke futhi ngaphansi ko 430 ke lapho ke futhi inkosi enkantolo lapho kade ku-include JA lapho ke athi ngesikhathi kade kusenzeka lokho ke ushuthi noma eqhathanisa ke lapho ke athi inkosi enkantolo kwamele lokho ikubukisise ngendlela eqondile futhi ngendlela ekhethekile ke lobu lofakazi obulandelayo ke noma mhlawumbe ebufakazi obulandelayo labo ke lapho khona ke kwamele ukuthi lokho bakwenze benze iqinisekiso ubufakazi labo buyahambisana bonkana futhi bonkana nofakazi babantu ade bevula icala lapho ke buyahambisana nofakazi bonkana babufakazi esube bezolothwa ngaphambi kwenkosi enkantolo lapho ke besathi ummeli lapho ke uma eseyafuka lapho ku 14.2 lapho ke athi cace bha ukuthi lapho ke lokho akaze kwenziwe ke lapho ke noma kade akwenziwe ngendlela ekhethekile lapho ke ngoma uma sekukhona lapho ngeCorrectional rule ke lapho ke somthetho okhethekile lapho ke ubufakazi oshuthu lapho obuquka khona ke abasola bonkana noma bafaka ngaphathi abasola bonkana ke lapho ke bathi lapho ke ufakazi oyedwa lapho uZungu ke wena ufakazi bakhe futhi nabo ke akade bungahambisani ngaso sonke ke isikhathi lapho ke ngoba kumayana nenkulumo yakhe ke uZungu yena ke into ekhuluma ukuthi yena ke kade ehamba ke lapho ke noZungu ngaphakathi kwemoto ngesikhathi besiya lapho ke elokozana ekulenda kade beya kuyona ngemuva ukuthi athole ucingo eqhanga uqhamuke kugwabeni emcela ukuthi akahambe ayodobha ulokozana omunye kuZungu lapho ke Carton Center yakhe eceliwe lapho kusikhumbuzo uZungu kena ke egoli ke athi uZungu ngesikhathi ade kusenzeka lokhu ke futhi wafika ke ehostel sohlangana nabo ke abasolwa ke lapho ke athi ngesikhathi bahlangana nabasolwa ke hostel ke lapho ke athi uyena ke ugwabeni owamazisa ke kubona ke abasolwa ke lapho ke noma lo hlelo uthile bona ke bazane ke lapho ke bathi lo hlelo lwenziwa ke lapho ugwabeni ke ngemuva ukuthi kwenziwa lokho ke bathi uZungu buye futhi wakhuluma khona njalo ke lapho ke athi khona ke lapho ke umuntu wakhuluma naye lapho ke umsola wesihlanu ke lapho ke ngesikhathi edemcitha akasuse ke imoto yakhe ngemuva kwemoto yakhe ke la kade imise khona ke ngoba uZungu imoto kade hamba ngayo kade ime ngemuva kwalapho ke noma umsola wesihlanu umuntu kade ehamba ngayo kade ime lapho ke nayo ke futhi bathi uZungu futhi nabanye ke lapho kade behlezi lapho ke phansi besijabulela ke lapho ke bese bahamba bothenga ke lapho ke iphuzo ke zokudakwa ke lapho ke bahamba basebenzisa ke imoto yakhe kuyiuno lapho iuno imoto yakhe besebenzisa lapho kade behamba lapho ke futhi bathi ngesikhathi kade behamba kade khona kumsolo wesibili umsolo wesithathu nomshayeli futhi ngesikhathi behamba bonkana kade kade bebahlanu ngaphakathi kwaleya moto ngesikhathi lesigibeshara behamba ngayo ke lapho ke bathi uZungu yena ke lapho ke yena ke wakhuluma njalo ukuthi yena ke umuntu wahamba naye kumsolo wesibili futhi nomsolo wesithathu.
In his affidavit dated the 23rd of May 2023, which was obtained some 4 years later after Brigadier had taken over this investigation, page 2, paragraph 4, line 10 to 11, Zungu states the following, and I quote, I must also at some point went out to the shops to buy some alcohol and drinks with a certain lady and came back to Gwabeni's house. Close quotation. It is clear that Zungu does not place the accused, that is accused number 4, traveling together using the VW Polo hatchback grey in color that he alleged accused number 5 was using, leaving the hostel, and part of his evidence is that he saw accused 1, 2, and 3 following each other, going towards Gwabeni's room, and he followed them. Inside the room, accused 1 was in possession of a .38 special revolver, and accused number 3 was in possession of a 9mm pistol. Accused 5 came inside the room. He was followed by accused number 4. Zungu states the following at page 2, paragraph 5, line 1 to 3 of his affidavit, and I quote, "Around 9 p.m. on the very same day, I noticed Moses Spear Mafiga, open bracket, Sunday Sontanzi, close bracket, and Kani, open brackets, Fisokuhle Zungu Ntuli, close bracket, walking after each other to Kwabeni's bedroom from outside. He does not mention accused number 4, following accused number 5 to Kwabeni's room. At page 2 of his affidavit, paragraph 5, line 6 to 9, he states the following, and I quote, "I saw Moses giving Kwabeni a .88 special firearm and Kani giving Kwabeni a 9mm firearm," close quotation. At page 2 of his affidavit, paragraph 5, line 20 to 21, he states the following, and I quote, "Mthozi Seni Mapisa and Carlos Ngube walked into the bedroom and sat on the bed," close quotation. There are material contradictions between Zungu's evidence in chief and his written statement. The correct approach to any contradiction between the prior statement and the witness's testimony was, in respect, most useful, summarized by Olifield J.A. Instead versus Mafada Fidiso in another, 2003, volume 1, SACR 583 SCA. The head notes in that case is submitted accurately, reflected, was said and was cited by Nechben J. Instead versus Governor and another, 2006, volume 1, SACR 322, capital letter E in bracket. In respect of the factual evidence of Zungu's evidence, the contradictions are material and affect his credibility. During cross-examination by Mr. Ramsepel in respect of Zungu knowing accused 2, this is how Zungu responded, and I quote, Mr. Ramsepel, "Now, accused number 2, because I will chop and change with respect to accused 1 and 2, but accused 2 himself says he does not know you in total. He just see you here yesterday in court, Mr. Zungu. If that was said or was coming from accused 3, 4, and 5, I would have agreed with you. Okay, where I was born or back home, where I was born, or he is Ndanzi. It is clear from Mr. Zungu's evidence, when question is posed to him by Mr. Ramsepele in respect of him knowing accused number 2, his response was that if that was said by accused 3, 4, and 5, that they do not know him in total, he was going to agree. The response by Zungu is a clear indication that he did not know accused 4, in the light of the fact that he says he was going to admit that he did not know accused 4 if such assertion was put to him by accused number 4. During cross-examination, Zungu testified that a typed version of his statement was made out of notes that he had written himself. And where there are contradictions in paragraph 5, he actually meant accused 4 and 5 entered Kwabeni's room and not accused 3. During cross-examination by Mr. Ramsepele about Zungu mentioning in his written statement that he went to Top Spa to buy liquor in the company of a lady, this is how Zungu responded. Mr. Zungu, I think maybe it is a manner in which it is put here, but I did go to Tops with the gentleman. We came back and then there is a lady that just want to go nearby, who had requested me to buy her a drink, and I did go out with that lady. In his evidence in chief, Zungu testified that the person wearing a cap was accused number 2 when he was confronted that in fact the person wearing a cap was accused number 4. He could not proffer any explanation. Zungu testified that at some point he met Brigadier Shabane, who informed him that he was going to conduct his own investigations, and thereafter he would come back and inform him, but did not tell General Shabane that he was at the hostel. The reason was that he did not want to give General Leshabane this information, that it was coming from him, and that he did not have certainty with regard to that. Clearly, Zungu had an axe to grind for the accused when one considers the compactness of his evidence. Zungu testified further that on the 13th of November 2013, he had a meeting with Brigadier Gininda. Brigadier Gininda asked him what he knew about the killing of Senzo Meyiwa. He told Brigadier that he knew nothing and there was nothing that he can talk about. Brigadier Gininda told him that he was going to do his own investigations. At that meeting, Brigadier Gininda was with Brigadier Tony. Zungu testified that the relatives of accused number 1 wanted to shoot him. He spoke to accused number 1 over the phone and asked accused number 1 why his relative wanted to shoot him, because he, Zungu, also did not know anything about this matter and did not know anything. It is clear, my lord, that from the responses or the evidence of Zungu, he mentions that not even on one occasion that he did not know anything about this case. He said this in the presence of General Leshabane. And on the 13th of November, when he had a meeting with Brigadier Gininda, he repeated the very same assertions that he did not know anything or knew nothing about the killing of the deceased. Thirdly, he mentioned this when he spoke, as he said, to accused number 1, when he was making inquiries about why his relative wanted to kill him, because he did not know anything about this case. Further, to proceed, Zungu could not explain what was the occasion on page, I'll come back to that, of Exhibit C, despite claiming that he was with accused 3 and 4 on the day of that occasion, the date of the 26th of October, 2014.
But you're saying Zungu's evidence is not corroborated in any of the evidence led in this court?
Yes,
Never.
never.
Remember, what's the time they say?
It's 11:30, my lord.
Yeah. Well, you remember there was evidence by Buthelezi, a gentleman called Buthelezi, who went to see accused number 1 to give him some washing items. Sorry, number 2, yeah, you're right. In Rustenburg, next to some supermarket there.
Yes, I remember that evidence, my lord, very well.
Yeah. And then there's another piece of evidence. I don't know if it's accused number 1, who was drinking Irish whiskey and exclaimed that Senzo is no more. Senzo is no more. You don't remember that?
I remember that.
Okay, on that note, let's go and have a drink.
kobugebengu lapho-ke abathi futhi iphuzu lesithathu ukuthi abe nenhloso futhi enze lokho ngokuyimisela ekuthizeni naye-ke adlale-ke isikhangiso kulobugebengu-ke lapho-ke bathi futhi iphuzu lesihlanu ukuthi nake futhi abe khona ngaphakathi kulophuzu lesine-ke lapho-ke ukuthi naye abe khona-ke futhi ngaphakathi ekwenzeni kobugebengu-ke lapho-ke futhi iphuzu lesihlanu ukuthi lapho-ke naye futhi abe nenjongo yokuthi zeni-ke naye abe nesandla ekuthizeni babulale noma-ke busola naye basho khona ukuthi umsolo lapho-ke lokho yena-ke bekumele abe nalo ulwazi lwakho ukuthi yebo lapho kade behamba bekwenza lokho-ke athi mayelana phecelezi udaba lolu becaphula phakathi icala lombuso libhekene necala likamgedezi-ke lapho-ke kade bekhuluma ngalo ngaphansi kwe-constitutional court lapho-ke lana-ke eNingizimu Afrika-ke ngesikhathi becaphula-ke lapho kummeli wenu-ke futhi eqhubeka washo khona njalo phecelezi nodaba lwenkulumo ekade lethiwe lapho-ke uZungu-ke ukuthi uZungu yena-ke into ayikhuluma noma inkulumo eqhamuka kuyena-ke ukuthi lapho komsola wesine-ke lapho-ke kade angamazi futhi uZungu yena akakazi kukuthi futhi uZungu wahlangana nabo-ke lapho-ke hosteli egwabeni-ke lapho-ke futhi kwaba ugwabeni owazisa-ke abantu laba-ke kuyena-ke uZungu-ke ukuthi naba-ke abantu abathizeni-ke lapho-ke bathi uZungu ngemuva kwesikhathi-ke lapho bahlangana futhi umsola wesine futhi umsola wesibili uqala nowesibili nowesithathu-ke lapho-ke ngesikhathi ade bengena ngaphakathi lapho kumuzi kwagwabeni-ke lapho-ke bese-ke nomsola wesihlanu wahamba wongena ngaphakathi kwala muzi-ke ngesikhathi umsola wesihlanu engena ngaphakathi-ke lapho-ke kade asalwe emuva komsola wesine-ke lapho-ke bathi futhi uZungu khona-ke la inkulumo yakhe bengahambisani khona-ke futhi bekakhuluma futhi abuye ayilungise phecelezi nenkulumo yakhe-ke lapho-ke bathi kwesinye isikhathi uZungu washo khona njalo-ke lapho-ke ukuthi bekayimisele ukuhamba ngemoto yakhe kepha-ke ngesikhathi bekazimisele ukuhamba ngemoto yakhe-ke athi kula uqapha khona ukuthi ukhiya wemoto kade ungekho-ke kuyena bese washayela-ke bese ugwabeni-ke washayela-ke umuntu thizeni-ke ekhuluma naye ucingweni phecelezi nodaba lwezikhiya-ke lezi yemoto-ke lapho-ke bathi uZungu nawe cabanga ukuthi mhlawumbe umsola wesine-ke logwabeni beyakhuluma naye ucingweni phecelezi nodaba lolu-ke lwekhiya lemoto-ke kepha athi umuntu kade bembiza ngegama noma igama lakhe kade bembiza njengokuthi umuntu kade kumzala-ke lapho-ke bese nokucabanga ukuthi mhlawumbe bikade kumsola-ke wesihlanu-ke loyo-ke bekasishayela ucingo kepha akakaze aliphendule-ke ucingo lwakhe-ke lo muntu loyo-ke wabuya futhi uZungu wakhuluma phecelezi nodaba lwenkulumo yakhe-ke lapho-ke noma phecelezi nodaba lwekhiya lapho-ke la wathiwe khona ufakazi bakhe ukuwukuthi lapho-ke ngesikhathi kade kusenzeka lokhu-ke lapho uZungu wakhuluma ufakazi bakhe ukuthi lapho umsola wesine-ke wafika-ke lapho-ke ngemuva ukuthi afike kwese wamnika lapho ikhiya zakhe zemoto futhi-ke ngesikhathi eqeda ukumupha ukhiya bemoto-ke lapho-ke athi nabe kajabulile futhi bekasebenzisana nje kahle futhi wamshala-ke izandla lapho-ke washo khona njalo uZungu ngesikhathi ethi ufakazi bakhe lapho-ke ekhuluma phecelezi nodaba lolu-ke lohlelo lakhe kuthi na-ke lapho-ke lokhu bona-ke akakazwe abezwe-ke bekhuluma phecelezi nalo hlelo lwabo-ke noma bezwe mhlawumbe noma ababone bevele bekhulumisana beqeda bonkana abasola lapho ukuthi bezohamba webulala-ke lapho-ke umufi-ke wabuya futhi ummeli washo khona njalo ukuthi mayelana nodaba lolu-ke lapho-ke phecelezi nodaba lecala leli likamgedezi-ke athi uma ngabe-ke abantu behamba bebulala kumele ukuthi sibe khona-ke isivumelwano lapho bazothi bavumela khona-ke ngento eyodwana-ke futhi kukhona-ke amaphuzu amahlanu-ke lapho-ke aphule khona-ke lapho-ke ummeli iphuzu uqala ukuthi lapho-ke kumele ukuthi umuntu-ke abe khona ngaphakathi kwindawo yesigameko lapho-ke bathi khona-ke njalo-ke kepha kumsola wesine yena kade angekho-ke lapho-ke ngaphansi kwale ndawo yesigameko ngesikhathi kade kusenzeka lobugebengu-ke lapho-ke bathi futhi kumele ukuthi umuntu abe nolwazi lokuthi yebo siyahamba siyohlasela-ke lapho nonke ahambe kuyohlaselwa-ke lapho-ke bathi khona-ke njalo umsola ngamunye-ke lapho-ke kwamele ukuthi azi ukuthi udlala isikhangiso siphi uma ngabe kusenziwa-ke lolu hlelo-ke lapho-ke bathi kepha-ke abukho ubufakazi obusho khona njalo ukuthi umsola wesine-ke lapho-ke yena kade analo-ke ulwazi lokuthi bahamba bokwenza lokho-ke kule ndawo kade isenzeka kuyona-ke lobugebengu-ke lapho-ke bathi futhi kumele ukuthi naye enze futhi ngenjongo noma mhlawumbe enze ngento ngendlela futhi ekhethekile ethizeni-ke esikhathi esikhangiso-ke lapho-ke bathi khona njalo kwabukho ubufakazi obusho khona njalo lapho umsola wesine-ke nakhe kade akhona-ke lapho-ke futhi naye wahambisana nabanye-ke bonkana benza njengethimba noma njengeqembu-ke lapho ngesikhathi kade bekwenza-ke ubugebengu lobo-ke bathi futhi kwamele lapho wasebenzisana nabo-ke abanye futhi ozakwabo-ke uma ngabe sebesenza lo bugebengu lobu-ke bathi futhi lapho kuyasho khona njalo umsola wesine-ke lapho-ke akukho la kusho khona ukuthi naye kade akhona-ke lapho-ke futhi noma kade analo-ke ulwazi, besathi futhi kumele ukuthi abulale ngenhloso-ke lapho-ke. Bathi khona-ke njalo futhi uma ngabe sebesenza lokhu kumele abulale njengenhloso-ke njengabanye-ke lapho-ke abasolwa-ke ekuthizini bafezekise ilokuzana ithimba labo-ke noma mhlawumbe ukuhlela kwabo-ke kwezinto njengethimba-ke lapho-ke. Bathi khona njalo umtholo wesibili-ke lapho-ke na-ke akanalo ulwazi futhi akakazenze lokho-ke ngenhloso ekuthizini-ke abe nesandla ekuthizini-ke umufi ashona.
The effect of failure to call available witnesses. The failure of a party to call a witness could, under certain circumstances, justify an adverse inference against that party. It is generally true that where a party fails to lead evidence, available evidence, which can clarify the facts before court, such failure leads to the inference that it is feared that such evidence will expose the facts unfavorable to that party. In this regard, my Lord, Ms. Kelly Kumalo was not called to testify despite being the complainant on the third count of the indictment. An adverse inference will be drawn in circumstances where the state failed to call another witness or witnesses as corroboration, where such witness or witnesses were available to give evidence and was in a position to clarify facts relevant to the case. Evidence of identity. Evidence tendering to prove the person's identity may be direct or circumstantial evidence. Direct evidence is the testimony of the witnesses who says, for example, that he accuses the person whom he saw emerging from the shop at midnight. I submit that there is no witness or witnesses that place accused number 4 at or near the scene of crime. The witnesses who testified viva voce before this court did not implicate accused number 4 as one of the intruders, or that at some point they, that is the intruders, after they had fled, another intruder entered the house. The assertion by Brigadier Kininda that accused number 4 entered the house must be rejected as false beyond reasonable doubt, as they do not find support from the witnesses. It was Sitwala who ran out of the house after shots were fired. Did not mention this, nor it was raised by the state in examination in chief or when the state was leading this witness. No, the witnesses, Ms. Makete and Mr. Ngache, observe another intruder after the two intruders had fled the scene, coming out of the premises. Despite Brigadier Kininda, my Lord, reading the confessions, it is clear that he did not do any investigations in order to corroborate and find evidence alluding to the commission of the offense. I'm basing this because if it is true that accused number 4 entered the house after the two intruders had left, this was supposed to be investigated, and no investigation emanated from this point. The DNA evidence and fingerprints. Captain Mamshedi Phineas Masetla testified that he was the senior forensic analyst and in the service of the state. He undergone training when he joined the Forensic Science Laboratory in 2002 with reference to opening of parcels containing biological evidential material, the preliminary testing of body fluids thereof, and DNA techniques which he had offered knowledge and skills for forensic biological analysis. He testified that he received continuous training with the Forensic Science Laboratory up until 2006. He had approximately 25 years' experience in the biological sciences. He was responsible for analyzing the DNA results in terms of doing the interpretation of the DNA results. He will then do what they call DNA comparison, where he will then have a case like this one, where he will have the DNA from the exhibit, from the scene, and they will also have the DNA results from the reference sample. The reference sample are the samples that are taken from the suspect or accused individuals. Captain Masetla further testified that he compiled what he got from those particular exhibits when conducting his investigations. The net number allocated for the exhibits from the scene is lab number 217731 of 2014, and lab number for reference sample is lab 126265 of 2016, phosphorus case 636 of 10/2014. The exhibit and reference samples were contained in Exhibit X11 of the record. On the 9th of October 2023, the records depict the following at page 75, line 2 to 4. Captain Masetla. At number 22, which details the description of suspect until Senma Peace accused for, was excluded from all the samples. Those quotation. A report compiled by Captain Masetla, Exhibit X12 in bracket, contains a table where the relevant results from the exhibit from the scene and reference samples are compared. The first sample is written sample with an indication of 1, that is swap 1, which has the container number 14DCAH8988 and contained in back number PA400 2150107, which was taken from the door handle of bedroom 1. The next exhibit is a head, which is Exhibit B on the head DNA, and is analyzed with presumable high friction area. In simple terms, it is a sweat. A head was in evidence sealed bag number PA3000 788535. Captain Masetla received the first reference sample for MZ Mapisa in container number 19DBA F0198 in seal bag number PA400 4638062. The second sample that he received was from Towson Mapisa in container number 13DBAD 5906 in seal bag number PA500 2176171. On the 9th of October 2023 at page 77, line 1 to 6, Captain Masetla said the following. When you go to the next column, it is written gender marker or Emala Godin, which tells us the donor of that particular sample, if the donor is a male. If is a male, it will be XY, and if it is a female, it will be XX. In the context of a gender marker, if you have XY, it means that particular mixture, it can be a mixture between a male and a male individual, or simply terms, it can be a mixture of both or more than one male individual. So, and as well as if you still have that XY, it can be a mixture of a male and a female individual. So when you look at XY on a mixture DNA, you must always remember that XY, it does not mean that that mixture is an only male individual mixture. So in a mixture, that XY represents XS, which is a female, or XY, that is from a male individual. He testified that on the 10th of October 2023, page 2, line 13 to 24. My Lord, it is important that before I start checking whether I find that DNA in the swab or in the head, is that for us to say a person is included, you must have to include the person in all DNA regions. So reading a person in one single region does not mean that that person is included in the mixture. Mr. Prosecutor. Now, what is the position if you read that person in more than one region, Captain Masadla? If you read him in more than one region, you must not, for you to conclude that that person is a contributor of that mixture, we have to read him in all the DNA regions. There was a question by Mr. Malloy to the following. Are there any of these regions or loci that are more important than the others? In other words, that are more distinguishing? Captain Masetla asked that the following. We, in terms of distinguishing the character of the loci, we use them in combination to give us a distinguishing factor. So we combine them. It is not necessary to say we attach more importance to one than the other. We match importance to the combination of them all together. From what follows from the evidence of Captain Masetla, my lord, was the analysis and comparison of swap 1, assembly head B, and various reference samples of known individuals, including Sen Mapisa, accused number 4, and he came to the following conclusion. The donor of the following reference sample were excluded as the donor of the DNA on the swap 1, 14DCA H8988, and the head B presumable high friction area PA 3000 788 Phosphorus CAS 636 of 10, 2014. The importance of this report or results, my lord, is that circumstantially it further excluded my client, accused number 4, in the commission of the offense. The sole purpose for the head to be sent to the forensic science laboratory was in relation to the friction area, whether one look at whether the head has a sweat, not as what Brigadier Kininda wanted this court to believe. He did his own analysis, which do not find support from the report by Captain Masetla before court. Brigadier Kininda merely says that because the accused, that is accused number 4, is read in one of the regions, then one can conclude that such a report is positive. That does not find support, my lord, from the evidence of Captain Masetla. And Brigadier Kininda further testified that because the accused is read in one of the regions, it is possible that he had touched the head. That was not the sole purpose for this head, the exhibit, to be forwarded to the forensic science laboratory for examination. The evidence of Sergeant Vusumuzi Mohane. Sergeant Vusumuzi Mohane testified that he is employed by the South African Police Service attached to the National Court Cases Unit. He testified that on the 20th of June 2020 at about 2100 hours in the evening, he was in the company of his colleague, the late Sergeant Mabena, when he arrested Bongani Ntanzi, accused number 2, at Phokeng in Rustenburg. On the 19th of June, accused 2 appeared before Lieutenant Colonel Rapado for a confession at Moroga Police Station. Accused 2's confession statement was admitted as Exhibit HH of the record. On the 24th of June 2020, the accused appeared before a magistrate, Ms. Cronje, for a second confession statement, Exhibit JJ, of the record. On the 6th of October 2020, acting on the information that accused 2 had provided in his confession statement, Brigadier Gininda arrested accused number 4. Brigadier Gininda considered in his evidence in chief that he arrested the accused, that is accused number 4, based on information provided to him, that is Brigadier Gininda, by accused number 2 in his confession statement, that he, Brigadier Gininda, had no evidence against the accused, that is accused 4, before the confessions were obtained. Confessions not admissible against another in terms of Section 219 of the Criminal Procedure Act 51 of 1977. Section 219 of the Act provides that no confession made by any person shall be admissible as evidence against another person. In the Constitutional Court decision of Mhlongo and Nkosi versus the state, which was penned by Judge Theron, or Justice Theron, the crucial issue, my lord, was the admissibility of extrajudicial statements of accused against a co-accused in a criminal trial. The issues arose in 2 applications in which the applicants seek leave to appeal against their conviction and sentences. The court, that is the Constitutional Court, was called upon to determine the constitutionality or constitutional validity of the admissibility of these statements. At paragraph 18 of the judgment, the Constitutional Court justices find the history of the common law prohibition on extrajudicial statements against co-accused. At paragraph 18, I quote the following. At common law, the extrajudicial statement of an accused was inadmissible against a co-accused. This common law prohibition stemmed from English common law. In 1832, the Court for Crown Cases Reserved in R. versus Turner was called upon to pronounce on a conviction for theft. The conviction was based on the evidence tendered in a confession of a co-accused who was an employee of the complainant. The court unanimously held that the confession of an accused was inadmissible against a co-accused, and the conviction was thus wrongfully made. Close quotation. A confession of one accused may not even be used indirectly against the co-accused. What is meant appears from the judgment of State versus Batman, 1960, Volume 3, SA 535, capital letter A in bracket. In which case the 3 accused were convicted of murder. One of them made a confession implicating the other 2. All that connected the confessor to the murder was his confession, and all that lined the other 2 was that the 3 were in each other's company on or at about the crime of the offense. Although the direct implication of the other 2 in the confession was therefore correctly left out of the court's considerations, neither JA found on appeal that they were nevertheless indirectly and wrongfully connected to the murder thereby. The decision based on Wigmore paragraph 1076, an English decision in R versus Turner, 168 ER 1298, and the appellate division decision in R versus Nkosi and Zulu, 1950, Volume 1, parenthesis all, H 91, capital letter A in bracket. Batman's case was followed by the appellate division in State versus Sorobe, 1968, Volume 4, SA 420A at 425G. A confession may not feature at any point in the chain of inference. Even indirect use of the confession for purposes of corroboration is not permitted. In this regard, see State versus Makeba and another 2003, Volume 2, SACR 128, SCA at 133, paragraph 14. It follows, therefore, that no reliance should be on accused number 2's confession as corroboration of Zungu's evidence, either directly or indirectly. My emphasis. Section 39, subsection 1B of the Constitution, which requires a court when interpreting our Bill of Rights provisions to consider international law. The term used is must. In terms of Section 39(1)(c), also indicate that reference may be had to foreign law, but not prescriptive. It provides that only the court may consider it when interpreting those provisions. South African courts actively consider international law when interpreting the rights to a fair trial in terms of Section 35 of the Constitution, ensuring that domestic legal procedures align with international rights standards. The English common law in relation to the admissibility of extracurricular statements is useful summarized in the following passage of Lord Helsham of St. Mary's-Bon, Hillsberg, Law of Evidence, 4th edition, 1990, volume 11, 2 in brackets at paragraph 1131, and I quote, confessions by one or two or more accused, where several persons are accused of an offense, and one of them makes a confession or an admission, that confession or admission is evidence against, only against the party making it. Where the statement is admissible, the information in it may be used to extract from the accused in the form of evidence made on oath all that he has formally said about a co-accused. Statements like acts done by one of several accomplices or conspirators in pursuance of a common design are evidence against the others, but statements which not made in pursuance of a common design are evidence against the makers. Close quotation. The bank records. In terms of Section 236 of the Act, the state produced proof of entries in accounting records and documentation of bank records, Exhibit EE, subsection 3 in brackets of accused 4. The relevant pages of bank records are pages 21 to 25 and cover the period from the 28th of August 2014 to 30 April 2014. The state indicated that the relevant pages of the bank records were page 24, the entries of 25 October 2014 to 27 October 2014, which depicts the following on page 24. There is nothing in the bank records, my lord, that suggests that accused 4 received any proceeds from the mastermind for the killing of the deceased. In fact, the record supports the accused version, and there is nothing that turned out of them in the state presentation of the bank records that implicates accused number 4. As they show the inflow and outflow of funds, which are immaterial in the present case. My lord, I'm informed that it is 1,300 hours.
Is that so?
Yes. May the court adjourn for lunch.
Thank you to Professor.
Bakit? Salulot.
Which word is on another call? What another number? 072. The 072 number. Yeah? No, akana iphone akayiphathanga, maybe phoning him on the wrong phone. Yeah, he was using my number. Hi, how am good? How are you, sir? Yes, and I must try and remember what you taught me. My goodness. Yeah, short and brief. Two. Is it the one? Huh? Okay. Okay, sharp. Oh, I'll try, guys. Okay. Well, Andrew, one of the main arguments, of course, is the fact that accused number 4 does not in any way feature in the evidence linking him to Senzo Meyiwa's murder. Of course, we've heard quite a number of arguments from his lawyer, that is Advocate Zitulele Nxumalo, who seems to suggest that there's no evidence linking him to Seni Mapisa to the commission of the crime itself. He says there are no witnesses that saw Seni Mapisa at the crime scene on the night that Senzo Meyiwa was killed, and this is despite evidence that we've heard that in fact he was standing outside as as one of the men who was guarding the crime scene during the commission of that crime. And that came from the confession of accused number 2, Bongani Danzi, who seems to place Seni Mapisa at the crime scene on that particular night, but he says there is no evidence or witnesses that seemingly point to